Okay, there we are. Okay, good morning. Welcome to this morning's session of the Kansas Court of Appeals, live by Zoom today. I'm Karen Arnoldberger. I'm the Chief Judge of the Court of Appeals, and I'm also presiding judge of this panel. And all that means is that I will be keeping time and letting you know when you're out of time. Or if you have more time left. You will soon learn that I am woefully inadequate at that task. I get involved in the argument and I forget to look at what time it is. But I'm going to try a new little thing today, which is a little timer on my phone. So if you look, and now I've lost it. If you see me looking down, you'll know that's what I'm doing. Also, I'd let you all know, and those in the waiting room that are listening, all three of us generally have computer monitors on each side of us. So if you see us look off to the side from time to time, we're usually taking notes or reading something involved with the case. So I just want you to know that we are fully engaged at all times. And as I said, I'm Karen Arnoldberger, the Chief Judge of the court. Joining me today is Judge Kim Schroeder, who hails from Hugoton and was a district judge for many years before he joined us on the court. And also joining me today is Senior Judge Richard Walker. Judge Walker was also a sitting district court judge for many years. And once he retired from that role, he graciously agreed to sit with us as a senior judge. So we're really happy to have him here today. Generally, I advise you that we know the facts of the case. You don't have to review them. We've read the briefs. We've read a pre-hearing memo that's been prepared by our staff. In many cases, we've even gone back and read or reviewed the transcript. So I usually tell you, you don't need to go into the facts of the case. But because we are live on YouTube and people will be watching this that may not know much about the facts, I will give the appellant about 2 minutes just to quickly summarize the facts that won't count against your time, just so we can get that on record. So with that, I'm going to go ahead and call the first. Oh, another warning, I think is still the case, Judge Walker, and correct me if I'm wrong. Judge Walker has had a little trouble from time to time with pop-ups coming up on his screen, and it causes his video to cut out for just a second. He's still on and he can still hear you during that time. And it's usually just a matter of a few seconds and he's back on. But if you see him disappear, don't get concerned. He can still hear everything you say. Is that correct, Judge Walker?
That's correct. Although what I'm using today there shouldn't be any pop-ups, I hope.
Oh, okay, good. It seems like every time we do one of these, there's some little glitch or another. All right, so with that, I'm going to call the first case today, case number 123084, Barbara Basinger versus Kansas Department of Revenue. Would the parties state their appearance, please?
Hey, please, court. My name is Charles Bradley. We represent the appellant in this matter, Kansas Department of Revenue.
Okay.
Fletcher for the appellee, Barbara Basinger.
Okay, and Mr. Bradley, you are the appellant in this case. Each side is given 15 minutes to argue. You're allowed some rebuttal time if you like. You can split your time. Would you like to have any rebuttal time?
Yes, please reserve 5 minutes for rebuttal.
5 minutes, okay. All right, so with that, you can go ahead and get started. Take a couple minutes to explain the facts, and then I'll start your time.
Good. But if I have time for the detailed facts, they are as follows. This is a driver's license suspension matter. It is suspended for failure to complete a chemical breath test. The agency action was given de novo review at the district court, and said court overturned the agency action, finding that plaintiff had met her burden. Throughout this process, it is the driver's burden to prove that the agency action and suspension is improper. Back in 2018, 2 officers were called to a residence for a report of an intoxicated female that needed help. When they arrived, they found that the appellee fell flat on her face, and she admitted that she had had a little too much to drink. Appellee could not stand on her own. The officers noted some blood on her nose and lip. After ensuring her safety and wellness, they transported her to the station for testing, as she had stated that she had driven there. Appellee was given water to clean the blood, and officers checked her mouth for obstructions or open sores. On the first attempt, the officers noted that she would go halfway, and then as soon as the bar reached halfway, she started taking short little breaths to the tube, end quote. The officers also testified that she was biting on the tube and not creating a seal around her lips, which allowed air to escape. The officers allowed the appellee to take the test again, but she continued to bite the mouthpiece and obstructed a valid sample. At trial, appellee testified that her fall was simply due to old age and oversized shoes. She also testified that she was unable to complete the test due to her facial injuries. However, she also testified and admitted that she was able to walk to the witness stand that day without difficulty. The district court held that she had met her burden and that it believed the injuries caused her to be unable to complete a test and that they were unrelated to the consumption of alcohol.
Okay, thank you. You can proceed with your argument.
Very good. Anytime someone in these DC 27 cases fails to produce a valid sample, whether that is an outright refusal to attempt or an attempt and a failure to sample, it's considered a refusal. One exception, unless the person shows that the failure was due to a physical inability caused by a medical condition unrelated to the ingestion of alcohol. And that creates three different things that the plaintiff has to prove. Sorry, the driver has to prove. They have to prove that there was a medical condition and that medical condition made it physically impossible to complete a sample. And furthermore, that medical condition was unrelated to the ingestion of alcohol. Now, the first issue of whether a medical condition existed is, I believe, requires some sort of medical testimony. The layperson is able to.
That's at the heart of your argument here, isn't it? That if you're going to claim that you cannot complete the test because of a medical injury, that there needs to be expert testimony regarding that injury. Is that correct?
That is correct.
Okay.
Courts have found that lay witnesses are not competent to provide reliable testimony about the effects of possible medical conditions. They can testify about the outside observations and such as that. And
there was no dispute in this case, was there, Mr. Bradley, that she was injured?
Correct.
Her nose and mouth were bloody. She was injured in this fall. That's undisputed. Is that correct?
It is undisputed that she was injured. The extent and the, I guess, medical effects of that have not been established. And that's the second part, is that even assuming arguendo that a medical condition was established, there has to be competent evidence to show the link between an injury or medical condition and an inability to complete the test.
Well,
and generally that's where
Mr. Bradley, didn't both officers at the time of her arrest and the breath test acknowledge that she had, they acknowledged and could observe she had injuries to her lips?
They saw that she had injured her lip and nose, so they made sure that it was clean, that there were no obstructions.
Well, I understand, but they observed that there was an injury, and an injury to your lip might affect your ability to seal it around a small little tube. That, what are these tubes, about 3/8 inch in diameter?
Roughly. And that's actually part of the crux of our argument. One of the defense is that the driver presented was that the officers conceded that a lip injury may interfere with the breath test results. However, the officers testified, both of them, that that was not the case in this matter. She was able to create a seal and she started to obstruct it. The officers have years of experience, and they indicated at trial that they see that whenever someone is biting on it or blowing out the sides of their mouth, which they observed in this case, those are not indicators of inability to produce a test. That is obstruction to produce a test.
Hey, Mr. Bradley, I have two questions. First, do we know how old Miss Basinger was?
We do. I would state that I believe that is.
How old was she?
I believe she was 72 at the time.
Okay. And tell me why this isn't just a credibility issue. The judge obviously, I mean, it was her injuries were apparent, and the judge obviously believed that she was having difficulty because of her injuries breathing into the tube. Why isn't that enough? Everyone could see and agreed that she had the injuries, and he believed her.
The main purpose is that, I'm trying to figure out the best way. The courts have established, and other jurisdictions have established via statute, a person's lay testimony, self-serving, is not sufficient to establish a medical exemption. Binding cases in Creasy versus Kansas Department of Revenue, a motorist testimony that attempted but unable to blow air sufficiently for a breath test has been held insufficient, absent other competent evidence.
I don't remember Creasy in particular, but wasn't that the gentleman who had asthma? So it wasn't something that was readily apparent. In this case, is there a difference because this was readily apparent to everyone?
Actually, Creasy indicated that it was readily apparent. The officer conceded that he was having a panic and asthma attack. The court reviewed the video and agreed with it. The main crux was that there was no medical testimony to show that there was a connection between an asthma attack and an impossible ability to produce a breath test. And that was one of the facts that I wanted to point out, that the officers noted she was able to fill up half of the tank. During a breath test, she was able to produce a half full sample before she started to loosen her lips and obstruct. That means that she was capable of creating a seal. Whether she stopped due to some sort of pain or whether she stopped due to other things would be, I guess, simply her own intentions, and we're unable to see those.
Mr. Bradley, as an individual blows into the testing device, does the pressure to blow build as you get closer to the completion of the test?
It is not. They ask you for a steady stream.
I know, but is there any, but that's holding your lips, or your lips that are injured around a small tube for an extended period of time. Is that correct?
Presumably, yes.
So the longer, is it unreasonable for the trial court to have believed that the longer she held her lips around that little tube, the more it started to hurt and she couldn't complete the test?
That was not part of the testimony. That was not part of the evidence. And furthermore, a hindrance to complete a test, whether it's discomfort or anything else, is not an inability to complete a test.
Mr. Bradley, I guess I'm not sure what you're suggesting she should have done. I understand in the case of asthma, you need to have a doctor come in or somebody medically knowledgeable and say, yes, this person has asthma, or a bad knee. I mean, these are not things that generally develop on the spur of the moment. What should she have done? She was obviously, by everybody's account, had injuries to her face and in areas that would impact her ability to blow. The judge reviewed all that and said, yeah, my impression is this would be a reason why she couldn't complete the test. I mean, should she have rushed to someplace, even though maybe it didn't require emergency room treatment? I mean, these things could have healed by a day or two later. What was she supposed to do?
Well, it is our position that she should have completed the test, that she was able to complete the test.
Well, I understand that. I mean, medically, if she wanted to document inability to blow, what should she have done, since her injuries were immediate and not chronic and long-term?
If she believed that her injuries were simply due to, I guess, a fall unrelated to alcohol, and that she was not under the influence, she had the ability to request a separate test. And she should have. If she had requested her own test and it showed that she was perfectly sober, I don't believe we'd be here today.
Was she told that she could get her own test?
I believe that is in the advisories, but not part of the evidence. But again, all of our binding precedent in Go ahead.
The officers knew that they also had the right to request a blood test from her too, right? When they saw that she was injured in around her face.
The officers can request any test that they wish to, more or more.
All right.
Furthermore, all binding cases regarding the inability due to a physical ailment have stated that lay testimony and the officer's testimony, that's insufficient to create an actual exemption in this matter.
And do they say that as a general statement that lay testimony is not necessary or is not sufficient, or are they tying it to the particular facts that are before them? That in the asthma case, lay testimony wasn't sufficient. In as Judge Walker said, in a bad knee case, medical testimony would be necessary. Right. Did they make a blanket statement that a person cannot testify about their own the effects of an apparent medical condition?
The courts have held that lay testimony is admissible and it can be considered, but every case that I have found that is binding precedent has held that with only lay testimony, it cannot be met. They have not said that medical testimony is required.
Right.
We have stopped at that point. Other jurisdictions have held, such as Pennsylvania, that medical testimony is required in this sort of instance. I believe Kansas statutes have stopped just short of that, just in, circumstances exist where honestly it's kind of obvious.
Okay. Thank you. I think you're out of time now. You'll still have your 5 minutes of rebuttal.
Very good.
Okay, Ms. Fletcher.
Thank you.
You may proceed.
May it please the court, my name is Heather Fletcher and I represent the appellee Barbara Basinger. As the court is aware, this case involves the KSA 8-1001P and whether the district court's decision is supported by substantial competent evidence. As to KSA 8-1001P, there is no language contained within the statute that requires that medical evidence from a doctor. Neither the statute nor the case law support that a motorist testimony motorist testimony without expert medical testimony is never enough to carry the motorist's burden. So the district court heard the testimony of Ms. Basinger. The district court heard the testimony from 2 officers. And the court also reviewed the video of the testing process. The factual statement in this situation is that there is that immediate and verifiable injury that was able to be observed. And in the words of the district court itself, they were obvious. If this were a situation, as the court has already noted, where it was a chronic condition that was not immediately observable, then the medical testimony might be necessary. But in this case, we're not dealing with that situation. The law in itself does not require us to abandon our common sense, and we are able to observe with our own eyes. And based on the testimony of Ms. Basinger, which was as a fact witness, as well as the corroboration by the officers and the video, there was substantial competent evidence as to the injury and to the face and mouth of Ms. Basinger. And a medical doctor isn't going to be required to testify that an injured mouth or may cause an inability to seal around a straw, or in this case, seal around the mouthpiece of an intoxilizer. The standard required is competent evidence and not competent medical testimony. Ms. Basinger had testified about her injuries, the basis for the injury, and that it was not related to the consumption of alcohol, that she couldn't complete the test. The police officers testified that the injury could cause a person to be unable to form that seal. And the testimony of the officers, along with that video, provided competent corroborating evidence to substantiate Ms. Basinger's inability to complete that test requested. The burden is on KDR to show that no competent evidence on which the district court could base their decision was presented. And the district court took into that consideration the testimony of the officers, Ms. Basinger's. It didn't ignore common logic. And it also considered the most objective evidence in this case, and that was the video itself, and which provided proof of Ms. Basinger's injury and supports the logical inferences that the district court found. The district court also noted that there was active bleeding, that Ms. Basinger was wiping her face, that she was rinsing blood out of her mouth at the time of this testing process. And the district court heard the witnesses, viewed their demeanor, and resolved the conflicting evidence that came out.
Well, counsel,
Yes.
what's the observation time required before this test can be done that there be nothing taken or disposed of from the mouth?
It's a 20-minute deprivation period.
So if she was rinsing her mouth out during that 20-minute period, there was never a true 20-minute observation period where she wasn't dabbing her mouth or having blood come out of her mouth.
That is correct. And she was actually provided water by the police officers during that.
Wouldn't that in and of itself make the testing process inadmissible?
Yes, Your Honor, it's non-compliant with the standards for the testing procedure, yes.
Well, and isn't that one of the conditions that must be met is that the officer at the time the test was administered observed the individual for 20 minutes and nothing was taken or discarded from the mouth during that 20-minute period?
Yes.
No burping, belching?
Correct.
No open wound. Isn't there also some reference to no open wounds in the mouth or around the mouth?
I believe that, but I cannot.
Isn't that one of the purposes that the officers check the mouth?
Absolutely, yes. Yes. You don't want any foreign substance to be in the mouth that could potentially affect the result of the test or enter into the machine itself.
Thank you.
Go ahead.
We would just conclude, your honors, that KDR did not argue that the facts included by the district court in both the facts and discussion sections of its opinion were untrue, nor did KDR argue that the video fails to substantiate the district court's findings. It's our position that the district court's decision is supported by substantial competent evidence and should be upheld. Thank you.
Thank you very much. Mr. Bradley, you have 5 minutes.
Very good.
You may proceed.
Your Honors, the third requirement and prong of that 1020p exemption is that the injury has to be unrelated to the consumption of alcohol. Now, in this matter, the driver testified that she was falling due to age, balance problems, large shoes, etc. However, again, this is not supported by any sort of medical testimony, simply why she fell. But honestly,
what information do you have or did you present that alcohol contributed, that consumption of alcohol contributed to her fall? Because we don't have a breath test. We don't even know what her level was. They weren't able to do field dexterity tests because she'd been injured. So what evidence do you have that her fall was related to alcohol?
Honestly, quite a bit. She admitted that she had too much to drink. She fell before she was injured, and the injury had nothing to do with her inability to stand. She admitted that she would not be able to stand. She admitted that she would not be able to complete any of the tests.
Was this after she fell? I'm talking about what evidence do you have that the fall was caused by her alcohol, except she said she'd had too much to drink?
Honestly, it's a logical inference. If she didn't fall without that, then.
So do people fall that aren't under the influence of alcohol? And I don't mean to try to be the defense attorney here cross-examining, but is that enough, do you think? You think that's enough for us to find that it was the alcohol that caused her to fall?
Absolutely not. But that's not the burden that we have today. The burden is that she has to prove that it was unrelated.
Mm-hmm.
As you stated, people fall without being under the influence. People get into
people that are 72 years old fall.
People get into accidents without being under the influence. However, whenever someone is in an accident and they have the odor of alcohol, they're not allowed to use this as an excuse.
Well,
In Moreland versus Kansas Department of Revenue, the person was substantially injured. He had head wounds, lacerations, a hematoma, which I'm not sure what that is. It was found that even though it was perfectly obvious that he was unable to complete a breath and blood test, because these were, well, they could not be shown that they were unrelated to the consumption of alcohol, he did not meet the burden of 1020p.
Which case was that?
That is Moreland versus Kansas Department of Revenue.
Okay, thank you.
And it's honestly a United States Supreme Court issue and years of precedent. I'll go ahead and cite another one. This is a public policy issue. Drivers who are drunk enough to pass out at the wheel, or in our case, unable to stand, pose a much greater risk. It would be perverse if the more wanton behavior were rewarded, if the more harrowing threat were harsher to punish. That is Mitchell versus Wisconsin, United States Supreme Court.
Thank you.
All right,
We are fortunate that this is the only injury that was sustained that night. She was unable to stand, but was still able to apparently operate a vehicle. The fact that no one was injured or killed is a blessing.
Okay, Mr. Bradley, what about my question that the 20-minute observation period was never really observed if she was bleeding around the mouth and taking water in during that 20-minute period, or getting rid of substances from her mouth because she was bleeding?
There are multiple issues within that, Your Honor. One, it was not briefed and therefore it was not raised as a petition. However, in prior cases, people are able to consume water to rinse out their mouth, to swallow it, etc. There cannot be any foreign objects. The officers testified and observed, looked inside of her mouth and said there are no open sores. There is no active bleeding. They were able to wipe away some of the dry blood. To be completely honest, the fact that the judge was able to see inside of her mouth for open sores better than the officers is perverse. It cannot be logical that the judge, through a video, was able to see the demeanor and the observations of medical injuries better than both officers.
But the judge has the
But we-
ability to either believe the officers or not.
That is true. My point was that looking inside to say that there are open sores, there's not substantial competent evidence to believe that.
Okay.
Well, it seems to me that there are three possibilities here, and I guess I'm not clear which of them or whether you're claiming all of them. The judge applied the wrong law, or the judge used the right law but misapplied it, or that substantial competent evidence doesn't support the judge's decision. Are you arguing all of those, or which? And maybe there's a fourth option, but those are the three that occur to me. What's your take on of those options? All of them?
Mostly it is that substantial competent evidence did not exist. However, he also ignored all the case law indicating that lay testimony is not sufficient.
Okay. Thank
Is
you.
lay testimony required to forbidden to testify as to things that are readily observable?
May I respond, Your Honor?
Yes, go ahead.
Okay, thank you. Lay testimony is admissible. However, it has been found that it is not sufficient to meet the 1020p burden. There's no binding case that has held that. Creasy has held that it is insufficient. Call has held that it's insufficient. State v. McFadden has held that it is insufficient. Moreland versus Kansas Department of Revenue has held that it is insufficient. And the Pennsylvania laws that mirror ours also find the same.
Okay, thank you.
Okay, thank you very much. That'll conclude this matter. We will take the matter under advisement and issue an opinion as soon as possible.
Thank
Thank you
you.
very much.
Have a good day.